Hi, everyone. Welcome to the Center for Innovation in Campus Mental Health webinar series. So, as usual, we're just going to wait 1 or 2 minutes for people to come in before we get started.
Somebody take notes, so, because I don't hear well when they ask.
Oh, yeah, di ba ganun?
Okay, so thank you all for joining us today. And our topic is health privacy issues on campus. So, just a number of things before we get started. Participants are on mute while we are on the webinar. You're on listen only mode. We will be taking questions at the end of the webinar, so feel free to type in your questions, even as the webinar is going along, and we will start taking them up around 12:45. The webinar is being recorded and will be made available on our website and as well as the presentation slides. We are actually, so this is the soft launch of our online community of practice. I'm going to talk a little bit more about that at the end of the webinar and also provide you with a link to where to access the slides, the recording, and also like an additional place for you to continue to ask questions. I'm just going to talk a little bit more about that later because I know you're excited to hear what our speakers have to say. My name is Perlin. I am the Research and Knowledge Exchange Coordinator for the Center. And today we are joined by Anna Tricini Felan, Meredith Garner, and Brooke Young. Thank you for joining us today.
Hello.
Hello, you're welcome.
I'm just going to read out a brief bio for them so that you know who they are. So, Anna Tricini Felan is currently the Chief Privacy Risk and Health Information Officer at the Canadian Mental Health Association, Waterloo, Wellington, and she has been there since 1988. She has an extensive background in developing and applying the principles of privacy and security of client records, the collection, dissemination, and quality of health information, and she has work experience regarding the transition to the electronic health record. Meredith Gartner is the Director of Services Regional at the Canadian Mental Health Association. She brings over a decade of leadership experience to the role, having worked with children, adolescents, adults, and seniors in counseling and treatment, first episode psychosis, eating disorder services, so a whole gamut of stuff. And Brooke Young is the Manager of Impact and Mental Health and Justice Services with extensive experience with quality improvement in the healthcare system. So with that all-stars cast, I'm going to turn it over to you now.
Okay, hi everyone. This is Anna speaking right now. Just to go over a little bit of our agenda today, and I just have a couple of disclaimers at the front end. First of all, this looks like a huge slide deck. Privacy and consent, they're huge issues. So what we're going to focus on today are most of the controversial issues that are found in campuses. That's why I brought in Meredith and Brooke. My expertise is in community mental health. We have been called recently around some suicides, some kind of prevention for our campuses right across Waterloo, Wellington. And my two colleagues here, they have the sort of context, and I just don't have that day to day. So I put together this slide deck around what I'm finding is common issues that we found in community mental health, but we tried very much to put it in the context of the campuses. So I'm going to be flipping through slides because there's a lot of them. Where I'm going to pause is the discussion points, because if you get anything out of today, we want you to get out the most important salient principles, because that's what privacy is that if you apply the principles, you'll understand it much better. So a little bit of an overview of privacy and mental health. I want to talk a little bit about FIPPA, which is not my wheelhouse. It is what universities must abide by. PHIPA is, and we're going to focus a little more on that because when it comes to campus mental health, that's the legislation that will come to the fore. And the common privacy issues, funnily enough, they're almost identical in community and on campus. Then we're going to talk about how the privacy culture on campus can be created, because you cannot have privacy without the framework. And so I'm going to walk through that. Slide number, or the sixth kind of point is, we have put together a scenario that I'm going to ask Meredith and Brooke to speak to. It's a common scenario that they have seen. And then we've given you a whole slew of privacy references and resources. And the very top one happens to be something from Wilfrid Laurier that really, really kind of, for me, when I did some research on this, was very, very helpful. Okay, so we're ready to go. All right, so first of all, why does privacy and recorded information about us matter? And what we found in mental health, and what I'm sure is true of the students, it does impact our lives, hopes, and future. So kind of principle number one is, whatever is written about you is highly, highly important, and it often stays with you, and it can impact your future. Just to give a little bit of a privacy definition, I'm only going to focus on the second bullet. The Harvard Law Review, as far back as 1890, defined privacy as the right to be let alone. As we go through this, we're going to find that in the year 2018, that right is very hard to give now. I tend to say there is no 100% privacy rights in the province of Ontario or Canada because of all of the exceptions. And one of the biggest things that I noticed, and so true with students, is that people tend to breach their own privacy by disclosing personal information, especially with new media, without considering the negative consequences. And it is coming back to the only defense is that people need to be informed right from the get-go before they start trusting a system that will not work for them. Oh, wait, shoot. So, where am I?
You're too far ahead.
Okay, yeah, so here I am. Sorry. Why is it critical to protect privacy? I can tell you in my 30 years experience as a privacy officer in mental health, I've seen it happen. I've seen people where the extreme sensitivity of personal health information, there's a lot more people involved in the delivery of healthcare. The now move to the electronic health record or the portability of PHI, there's a big emphasis on information technology. And then for me, one of the biggest issues that is not coming to the fore with my colleagues is that recorded information. More and more every day, I'm hearing it's not accurate. That's not true. And it is causing some pretty significant claims to the Privacy Commissioner. So the consequences if we don't pay attention to privacy, I can say I've seen the link to discrimination, stigmatization, psychological or economic harm. People will avoid treatment. They will lie about information. One of the ones I see all the time is when people want to get their disability or they're applying and they think if they hold back, if they have addictions problems, and I'll say to them, no, that addictions problem is a complexity issue. It's one of the reasons that added to your other mental health issues equals complexity. There can be a loss of trust or confidence in the health system. We're seeing that right now with people being very, very concerned about the electronic health record. And I like saying to people, don't worry, technology can be secure. It's whether that written record is accurate, is it valid? And then there's a cost in time in dealing with privacy breaches. In the province of Ontario, I'm now in the August of my career, and what I'm seeing are privacy people getting awards. There are now claims and they are winning them. There's legal liabilities. We have people now, I get at least, we're so big now, we're getting claims against around their privacy. And then the big one that I noticed while I was researching campus was that employers, potential employers, are looking on Facebook and are checking out. And then students who may not have realized that, you know, they were out in, you know, on one of the, you know, campus nights, and that shows up. So there's a real changing environment out there. I'm not going to go through them all. We're going to focus on FIPPA and PHIPA, but just simply said, FIPPA applies to the provincial institutions, like colleges, like ministries. MFIPPA applies to municipal institutions. You need to know that the Office of the Information Privacy Commissioner, of which now I know very well, they are the oversight. And then there's PHIPA, which is the one that I personally believe was made for us as citizens. I think if it's understood, if everyone had the same approach, the same standard, this legislation actually works for the common citizen. But unfortunately, because it's misapplied, highly misunderstood, that it in fact can be, the way it's interpreted cannot work well for our clients, our students. So what does FIPPA do? So bottom line, it's that information needs to be available to the public. There are some exceptions. It's decisions around disclosure of government information and needs to be reviewed independently. It protects the privacy of individuals with respect to their own personal information. Bottom line is our emails. For us in healthcare, it governs our emails, our texts, all of our HR information, our admin information. So when you work in organizations like community mental health, that information can find itself everywhere. It can find itself in finance, everywhere. So again, again, we need to put ourselves in our client's shoes or in our own shoes. Like I always say to people, you have to realize this could be your information. And again, the oversight is the Ontario Privacy Commissioner. Now let's look at PI. What is personal information? So it again can be recorded in any format. Remember, it's recorded information, and it has to be identifiable. So it has to have something of a personal nature to it. And if it's reasonable to expect that it can be identified, so if you don't have a name, but you have enough of identifying that'll say, geez, that's the person that was just on the front page of the news, and now they're coming to our organization. People don't realize that. They think if they don't say the name, that it's not recognizable. Well, I'm born and raised in Guelph, Ontario, and if I see something on the page, I could likely link it. And then it's a name that's combined with some other element like address, sex, age, and they're not exhaustive. There's a huge amount, and I'm only just scratching the surface here. When you come to PHIPA, which again governs organizations that are there for the purposes of healthcare. When I'm in question and wonder, is that person a HIC? Are they a health information custodian? I'll Google it, I go to their privacy policy, and I can almost tell immediately if they're a health information custodian or not. But this now is the standard and the norm, and it's actually, in my opinion, and just my opinion, not a lawyer, I think it's a really good piece of legislation. So the recent amendments that are really important to this is that for community mental health, we have to start reporting to the Information Privacy Commissioner as of 2019. Now, not every single breach, but there is a criteria and it's all available. The other big change is if one of your regulated health professionals are involved in that breach, there's an obligated reporting to the regulatory college. The fines have doubled, and our organization then doubled our insurance, especially as we got bigger and bigger. and then there's a limitation period for prosecutions has been removed, which opens up that due diligence to incident reporting, to privacy breach reporting, is just critical. But the biggest change for me, and I don't think people have realized this, Bill 119, which is the changes, is it's changed the definition of use to view. So just searching. So if you, like we run a Here 24/7, and just say they're looking for John Doe, and 5 names or 20 names show up under John Doe, and they decide to open each and every one when the first John Doe is the right one. Viewing information now, even if you don't totally look at the whole file, has changed the landscape. And then there's the added responsibility to ensure that PHI is not collected without authority. And our organization just recently figured this one out pretty good. We inappropriately collected something that had a big stamp on it that says, do not collect without the chief of police consent. So, we did that really was an eye-opener. And this, we have to report the privacy breaches. One of the things that I have been doing for some time, but I tell you it's hard to do, when you have that vexatious client that calls and calls, you have to tell them all the time, if you're not satisfied, you have the right to complain. And I find myself when I'm typing that on the letter, cringing, because it opens up. I have one situation that we spent over 200 hours just on a complaint. And we may still win it, but the reality is it takes a lot of time. The whole issue on researching. Now, the part that isn't clear for me, but I'm applying the research guidelines, community mental health, and I'm sure you're finding this right across the province, is that we do a lot of program evaluation. It's not research, it's quasi-research. So we've developed a checklist that doesn't require the REB because it's program evaluation, but it pays attention to the principles and guidelines that are inherent if you're doing something not for the purposes of healthcare, but for the purposes of research, of program evaluation. And by the way, anything that we refer to, we can pass it on if you want it. But I'm just saying, I'm not worried about research. Everybody seems to pay attention to that. It's all this slew of program evaluation that everybody is looking at. Agent rules have been updated. And again, this is so critical. And I know it's hard. And like if I have a new person coming in that's doing cleaning, we have to make sure that they sign pledges. We have a whole checklist for our agents. And you could look the other way, but boy, you're going to be sorry. I just have to say. The other big issue, if you do risk management at all, is that CICMH, which governed a quality of care review for sentinel events or adverse events, it's been rolled up into PHIPA. And where in the past, all you had to do was let the loved ones or the stakeholder involved know, would be all you had to do was tell them the recommendations. The biggest change now is that you have to tell them what happened. And in the last 2 that we've just done, it changes the whole way that looks. So it's very, very unique. And we have a checklist for sentinel events. It meets Accreditation Canada guidelines. It's something we've honed up. And we even have examples of apology letters and quality of care review minutes and how we put in all the legislation piece. You're welcome to have that as well, but this is a big significant change. I'm not going to go through the whole thing. There isn't an exhaustive list of health information custodians. Frankly, if you're working if you're providing services for the purposes of healthcare, you might as well, in my opinion, you're definitely, you have to abide by the HIC standard. Now, like I'll give you an example, like Meals on Wheels. They're not a HIC per se. They pick up food, and they have the name of the client in that, and sometimes they need to know if that person has dementia. But you mitigate risk by working out your processes that they just get that need to know information, and that we take on that oversight, and that's how we do it. So again, what is personal health information? And our clients don't understand sometimes that it does include family history. It does include the last 20 times you saw your family doctor and he said this and that. People, when they have access to their record, they get shocked at what they see on it. And the health card number is another part of it. This here could have a whole hour of discussion, but and we're doing it quickly. Now, this here is what came up for me when I was really researching campus records, is that there are mixed records. So in an educational environment, so you'll have your FIPPA school record, like in the school system, the OSR, I don't know what they call it in universities. But then you also have your record in that medical clinic or that health clinic or whatever's on campus that is part of it. So there's two records. But if it has personal health information, PHIPA will override FIPPA. So they're mixed, but in the end, if they come together, the way this slide explains, it's governed by PHIPA, which is the higher standard when it comes to personal health information. So sanctions for unauthorized access. You will be investigating. I've never seen so much progress since 2004. IPC, in my opinion, have fantastic resources, but they also are there. They do. I get calls from them. They are doing their job, in my opinion. And if any of them are listening, I mean it. They do prosecute when they know there are lawsuits. The colleges are getting more involved, and employers now are getting much more involved. So it's out there. I think privacy is no longer hidden. It's out there. So agents, I don't want to go through all this, but bottom line is you got a contract. They are near PHI. They clean your place. You need to have a clause. If they are doing personal, like mental health services or any kind of services, and they are a contract, every single contract we've done, like all our GP, all our physicians, all of our psychologists, anyone, any of the allied health, every one of them has a standard section around their obligations under PHIPA. We'll share those as well if you want, but it's better to have a standard one. Don't have a different one for each one because they're all the same. And it's really important. If you're not covered in that area, that will be a problem. So just around your obligations, I'm going to, this slide, what's important about it is you cannot talk about the rights and responsibilities of PHIPA or of privacy for your students or your clients unless you have the framework. It's impossible. If an organization or an entity does not have all these things in place, you will never be able to even attempt to do good privacy culture. People have to have the trust that when they walk into your organization, there is a privacy officer, your practices are posted, there's clear rules. I mean, people can't read those rules. You have to have a nice, easy to cheat sheet, I don't know what you want to call them. Our agents have to know, they can't be a surprise. You have to know how to respond to public inquiries, have statements ready. You have to, the information belongs to your student and or your client. That's bottom line. If people think they own the record, you're already off to a bad start. If you are an organization that is a big organization and you are in a health information network provider role, you need to have privacy impact assessments. Or if you're going to go mobile, and you're going to have people be able to see their information on a phone, you have to have a PIA. You have to take, again, this legislation, what I like about it talks about reasonable. You do what a reasonable organization will do. So everyone will say, well, great, Anna, you guys have the money. We do. We have, our funders have helped us to put in consent management and all this stuff. If you don't have that, then you work with others that do, and you share resources. The big one for us is I collect all our breaches. I have a quarterly reporting. It's going to be really hard to decide and to start in 2019 to start reporting. I think I had 4 this last quarter, and then you have to hold yourself very transparent and very accountable. And the most important one is It's all about what's written in that record. So those records of PHI, how they're retained, do you have a policy around retention, how they're transferred, how they're disposed of, and do you have evidence that they're disposed of? So I always ask for the receipt of the shredded guy. I need that receipt so I can prove that shredded it for me. Anyway, without this framework, it's really hard to do privacy the right way. I'm not going to spend a lot of time, but I want to make this clear. I mean, other privacy officers may not agree with me, but the best thing about PHIPA is the implied consent. If you do it right, if you have that on your website, you have a notice, you have things in your waiting rooms, you can rely for the purposes of healthcare on with implied consent. And people don't like to do that because they feel that they can trust a signed consent form. It doesn't work. It slows down service. And we can talk, that might be a question that comes up later. But it is a big deal. So take a look at this slide. That person in the middle there is a student. And by the way, Brooke Young is the one that is the genius on all these diagrams. I couldn't have done it without her. But what I want you to do, this is a dilemma. We're going to be speaking to this, but I want to drop a little kind of penny here. So there's this client that says, okay, if I'm at risk, what gets shared? What information is shared and why? Who can I ask? Is there a person? Do I have access to my information? When don't I have access? Look at all the stakeholders surrounding a typical student on campus. Mm-hmm. And then when you look on this other side, you've got the resident staff that is dealing with the crises. And then you've got another side that says you can't have it because I'm afraid of being sued. And you've got this whole dilemma, but the person in the middle is the one, that little guy or whatever, is the one that is at risk. And if we don't understand how to get him out of that maze of questions and help navigate through this privacy system by giving him enough information that he knows what his rights, he knows what his responsibilities, and he knows what overrides. That will help this whole thing in the end. Anyway, I want you to keep this little picture in mind. So consent in PHIPA, sorry, like I realized that the title later had been consent. I'm only going to put 3 slides. If there's interest, we can do a whole webinar on consent because it'll take at least an hour to do one. But I'm going to just talk about the most important part. In mental health and addictions, in community mental health, in children's mental health, under the Healthcare Consent Act, there really is no age of consent. We have allowed a 12-year-old that ended up being a parent in a family dynamic who was taking on the role almost of an adult. As long as, and I don't have it here, but we can send it. It is what I call my consent and capacity test on release of information. And it is a really small threshold, really low threshold. And it is basically does that individual, whether usually it's 12 or up, does he or she appreciate the risks and the benefits of sharing that information? Now, other than the obviously incompetent child or incompetent adult that is formally and clinically designated as incompetent, but that's not the issue. When you have that, you got some, but if a child is under 16 and a parent or a children's aid are involved, the info about the treatment, the child decides on their own. They trump in the end. And I know people don't like hearing this, but it is true. And I'll be really clear. You can't talk about a mass of children. This is child by child, teenager by teenager, adult by adult. Each case has its own scenario. And let me tell you, this whole subject is a lot. But if we're interested, we can do something like that. But under PHIPA, it links to the Healthcare Consent Act, and we've done okay with this, right? Mm-hmm. Yeah. Yep. There is a table. So a person of any age, if they're capable, they make their own decisions. If incapable, they need a substitute decision maker. But under the age of 16 or birth to 16 less a day, if capable, can make decisions about release of everything in his or own record, and a parent can also consent about any treatment or counseling if a child does not consent on their own. But if the capable child objects to the parent making such decisions, that child trumps. And I know a lot of health service providers that don't like this.
Mm-hmm.
So kids and PHIPA. For an incapable child, the parents together make decisions. If there is a separation or divorce, if you're only going to follow the instructions of one parent, you need papers to show one parent has custody, the other has access, or papers to show one parent is restricted. I always go to the custody papers. I notice the judges are now specifically adding who has the right to the information. Not years ago, but if you really look at that, I always ask for custody papers. I only want the need to know. I need to know what the papers say. So let's now, I know that's really quick on the consent, but I mean like capacity, but like I said, it's a big topic. So anyway, here's another dilemma. So the system is overwhelmed with some want signed express consent, which will bog down the whole system for the circle of care. Some will accept verbal express, but they have to document. Most, like our system for the purposes of healthcare, we've had to rely on implied consent with notice. Some have a combination, some have no consent. But I can tell you it's as dangerous to insist on signed express consent as it is to do implied consent with that one person that you may have missed. It's a big deal. So the other real important point here, which works for us.
Oh, sorry, go back.
Okay, go back. The other really consistent or really insightful thing that has worked for us in mental health and addictions is the more we can utilize PHIPA to be the vehicle around collaborative care and access, for the purposes only for healthcare. That in PHIPA, there's no requirement for express consent in the context of providing care between health information custodians. So that clinic in a university and CMHA, they're two hits that can exchange. And you can rely on implied consent if you're disclosing to a direct healthcare provider for the purposes of providing or assisting. Now, the police are a different story, and we're going to talk about it. And on campus, we're going to come up with the dilemma that I want to spend more time with. So,
Yeah, 15 minutes.
15?
Before.
Okay. So we need a consistent circle of care approach. I tried to influence CMHA Ontario that every single CMHA, we all use a consistent circle of care approach. Implied consent with notice works, but it doesn't work if some of us utilize that and some of us don't. So the shared care approach, Dr. Carol Orchard, Meredith and I saw her a few years ago. I was so impressed. She's from the University of Western Ontario, and she is in seniors mental health, and I totally agree with her definition. A partnership between a team of health providers and a person where the individual retains control over his or her care and is provided access to the knowledge and skills of the team members to come to a shared plan of care. They understand circle of care, but it has to be done in that manner. And it has to be done like nobody owns the whole thing. And this has really worked for us. So I like this slide. I do not think you can talk about privacy rights without talking about your service rights. And if I had to redo this for the campuses, it's your privacy rights with your student rights. They go hand in hand. And if everyone was on the same page, that handshake will really keep our students safe. Just a caution, implied consent with notice only works if it is about the purposes of helping for healthcare, but it's not for third-party purposes. Everyone has to make sure. You cannot just you can't use that circle of care directly with the police or for another purpose when the police will have a different purpose. Now, EMS is a different story. They're there for the purposes of healthcare. So just some exceptions. I'm going to flip through this so we can get to the controversial stuff. The usual stuff, eh? Like, I noticed a whole bunch of people are going to ask me about the SPCA. It's controversial, but there are ways of doing it that, because in mental health, it is an indicator of further risk and harm. So here's the tension between FIPPA and PHIPA on campuses. So both of them outline situations in which counselors, professors, campus security can disclose private and personal institutional information. There's this tension between protecting and disclosing. So that student who is psychologically vulnerable, or there's a potential for violence on campus. So the big example is the Virginia Tech.
Yep.
In hindsight, when they looked at it, everyone knew that he was a big problem, but nobody put that all together to share it. This legislation, both of them are reasonable around that. You err on life. But it doesn't mean for the person who's unmedicated, and you have to really look at it case by case, and not just use it. So the risk call, so there's a reasonable expectation of privacy by students. Reasonable to disclose private information for public interest. But in extraordinary circumstances, it is okay to name a minor, or in order to solve a crime, or potentially dangerous or emotionally at-risk students. Just make sure you don't have what people feel. You actually have evidence of risk information. So if someone is saying, I want to kill my professor, it's different than I think he might want to. Like, you have to really, there's a whole documentation training that goes with this. And that goes hand in hand. The documentation part, how you record it. You can't record your risk. You record, like, because you're hearing it, you record the actual facts and the risks that the person is demonstrating, showing. Killing animals, bullying a student, Facebook posts. You have to have some of that. Like, you cannot say, I just feel, like, he makes me feel funny. That doesn't work. So here's one of the big things that students and our clients, to tell you the truth, have a hard time with. So the duty to warn that is triggered when there's reasonable grounds that the disclosure is necessary for the purpose of eliminating or reducing significant risk. You do err on life. It still means, though, that it is need to know information. You don't share everything. You share the information the police need for them to do their next step. You don't have to share all, like, she had an abortion when she was 15, or all these other things I see shared, or, oh, by the way, the family is a long-term problem in the community. All this stuff that is not relevant. It's not relevant. Relevant is the word I'm looking for. There is the mandatory gunshot wound reporting, but there are others. There is, if there's significant risk, we can share with you. We have a whole list that we can give you that are exact examples. So I found this so insightful when I was researching the campus stuff. So this Martin Downing, he's an assistant professor at Wilfrid Laurier. I was very impressed with his whole article. There's a whole article he's done. The awareness that there is likely no reasonable expectation of personal privacy in any space, private or public, is one of the strongest arguments for personal discretion. And it just makes me go back when I do my training with the family. I have a group of family education. There are families that come in because their loved ones ill. And I say there is no 100% right of privacy anymore. So the more you know and are aware, the more protected. So the more we are as the providers, the more our clients, our students are aware. That's the biggest, best defense, because we can't guarantee 100% privacy. Yeah. So I'm going to quickly run through this. The students are aware of their privacy rights. Just put this in, and by the way, for everyone on this webinar, these are your privacy rights. These are all of them. I'm not going to go through them all. All of us, we're all citizens. These are our privacy rights. I want to quickly talk about lockbox. I don't know if the university is using that in their healthcare areas where they have healthcare provision, you should put it in. It is wonderful because there are people that says, look, I know the girl at the desk. Can you lockbox against her seeing my file? It has been our enabler for our clients that are paranoid, really upset that someone who they'll see at a wedding or a funeral, if you're Italian, you'll see them at all of them, they will say, well, did you know about that? Lockbox is something, if it's done right, is a wonderful enabler. I'm going to just go through it, quickly, because I just want to talk about the clinical impact. While Lockbox is really good, that conversation with the person that says, okay, if you lockbox me against another service provider, you're not going to get services likely, or services will be compromised. They have the right to be informed. So whenever someone, like I just had one recently yesterday that said he wanted lockbox, but then he said to me, but not if it disadvantages me. And I said, well, if you lockbox, it's going to disadvantage you. So I'm having another conversation with him. In the end of the day, if I was working in the on campus, I would be wanting to talk about the people responsible for the student record privacy, the people responsible for the privacy on the healthcare side, and those two privacy entities get together and harmonize your privacy policies, harmonize training, all of it. All these, we've done it in our governance with non-healthcare providers. We just did it today with our police. We've harmonized our privacy policies, and it works. Just some safeguard. I'm going to flip through these. You guys will talk about this. I'm going to get to the discussion. This document by IPC, if you put this in place in your infrastructure, again, you can actually give your students, your faculty, and everyone the framework for privacy. It's a wonderful document. So if you do all that, we have people that do feel safe, and they do trust us because we were honest, transparent, they were informed, and we built capacity within our clientele and within our staff. That's the answer. Just to give you a little idea, if your student walks through the system, if everyone's on the same page, you'll mitigate disaster. You really will. For that student that says, I want to go and blow up my students, then someone says, hey, if you talk like that, this is the consequences. It may have gotten caught quicker. Just again, these are all the things that need to be in place. How do we do it? Again, you harmonize, you focus on privacy risk, and here it says health information management. In the faculty and stuff, I would say information management. What are you collecting? How are you collecting it? Don't collect what you don't need. Inappropriate collection is as big of a problem as not enough. So make it a priority. Invest. Work together. All these government resources we share. We share everything we have because it's not our money. It's the citizens' money. And we have a set of tools that we like to share and use, and we keep learning. We learned something today from the lawyer of the police lawyer. It was really good information for us. So I'm going to pass it over to Meredith and Brooke for the scenario.
So in our conversations and discussions with campuses, we kind of come across this scenario that we kind of heard of most often. So it's 2 o'clock in the morning, and Stephanie's student goes into crisis, and likely if she's on campus or he or she is on campus, the most contact they're going to have will be with the residence life staff. They're going to have some element of contact with them and some determination, even at an early level of a risk assessment, or at least an understanding of what the risk is, and determination whether that person needs to go on and go into a hospital. So police, often campus police in most situations are involved. They're involved in transporting the student to the local hospital. There will be information that would be relayed from the residence life staff to police, and from police on to the hospital that will be assessing the individual. There may also be scenarios where parents, let's say Stephanie's student's roommate calls campus and says, we understand that our child something happened, whatever your practices and policies, maybe you're calling parents, parents, the students themselves may contact parents, and parents at some point will become aware and involved. The most frequent feedback we've heard, though, is that often what occurs is that Stephanie's student goes to hospital, she's seen by the ER physician, she's not placed on a Form 1, and she finds her way back to residence, and residence life staff have no idea what happened. They haven't heard anything from the hospital because, of course, they, at the end of the day, are not a HIC. They weren't provided with that information. The presentation for them is that Stephanie is likely still feels as much distressed or at risk as she was when she went into the hospital, maybe potentially a little bit less, but the issues and challenges still exist. And then the question becomes is trying to understand why the hospital discharge happened, and what the next steps were, and how do you link Stephanie's student back up to healthcare, who gets the information about what was in hospital, and how and who is communicating with parents. Does that give you enough?
Yeah, that's good. Do we want to say anything about the families, like information about the families?
Yeah, so you may have, residence life staff may know information about the family. There may be in contact, again, if the student lives in the same community, grew up in the same community that they're attending the institution where they're going to school is, then there may be a greater contact to family information, again, depending on the size of that school or community. Then it's also about the care planning, so next business day, with on-campus resources either in student health services or in counseling services, depending on how the university is structured, whereby parents are calling, they're paying lots of dollars for their child to be on that campus and be in the school. They want them to be academically successful, and they also want to know that their child's safe. And so there may be a need for ongoing academic accommodations related to support. So then you have academic advisors along and involved. And how do you manage that scenario?
Yeah. So can I just say something, because I missed the slide on families. The thing about families, this idea that you can't share anything with the family is not true. Families have the right to know if their child, was admitted to hospital, or if their child, there was an adverse event, and they need to know at minimum, even if the child says, I don't want my parents to know, at minimum, you're allowed to say that, no, they're stable or not.
Yep.
In the end of the day, the way we mitigate that risk is right at the get-go when they get referred to us. So and if you look at a campus, when they come in, that your systems are built in to say, look, in the event that something happens to you, who's your next of kin? And that's implied consent right then and there, that's right on record, that says, need to know information. You'll have the parent, like we do often, that says, did my child show up? I go straight to see were they indicated as the next of kin, and if they put a block on it, we have a conversation with the person that says, look, your parent, unless it's a perpetrator parent or something, where we wouldn't. But in most cases, it's a parent that just cares. We tell the parent, we're not going to tell you all the details, but we will let you know at minimum, and they understand that.
What we've worked out in our community here, locally with our local campuses, is to be able to be a partner with them in these kinds of scenarios. So giving residence life staff another option of calling our organization. As Anna mentioned before, we have the wonderful access to a program and service called Here 24/7 in our community, which is the 24-hour crisis service. It is wonderful. They're teasing me. So what we've been able to do is then work with residence life staff to really look at, is there another way that we can mitigate the risks and challenges that are happening in the after hours or outside of regular business hours of campus services, so that we can avoid the potentially unneeded visit to ER. And if we are going to ER, then we have a really clear plan about the level of risk that we can communicate, being a healthcare HIC, and communicate that to the hospital and work with that hospital system in navigating that approach and reintegration of that student back into campus. So we have a process by which we can contact the student health services or student counseling services, identify at-risk students that we've had contact with in the after hours, and again, develop a wholesome plan for that student and make sure that the on-campus resources are aware of risks that have happened in the after hours. Our experience is that there's little pockets of information about the story of a student that exists all over campus, and it's how do campuses come together to mitigate that challenge and understand what those risks are. Mhm.
Okay, I think that's it.
Wanna
Any
go to questions?
Yes, we can go to questions if you like.
Just a little, you already
Oh,
talked
those are
about it.
Chris, those are.
Yeah, those are all the resources. Yeah.
Got some resources at the end and
That's-
some references for you. There we go.
All right. Well, thank you so much, guys. That was a really great presentation. I think it answered a lot of questions that people have been asking. But we also do have some more questions. And I just want to remind everyone, like, now's your chance to be sending in your questions via the question function in the menu. So first question, my apologies. First question is, do you have any advice on how universities should communicate information to the campus about student suicide?
I think it depends on what your kind of campus policies are, where how public the death by suicide was, did it happen in campus residence. But at the end of the day, there's a privacy component to this, which is really about what the family's wishes are.
So this is not my privacy hat now. This is my risk management hat. I am actually working with our communications person. Under Accreditation Canada, one of the required organizational practices is that we post on our website the sort of a summary of our quarterly high risk incidents. So I'm going to work with Martin to focus on the learnings and what we're going to do different, and not focus on, we definitely can't link a story together. I know people love scenarios, but you will identify. But we are working on that. I can share what we get done. I'm doing that by May 15th. But otherwise, you have to be really careful.
We could also link you with the Center for Excellence. No, they're saying no.
Nobody's done this.
Nobody's done it? Okay, my mistake.
Maybe can't reach.
I think what I would say is that some of the challenges, it's really about what's the families. If the family's not acknowledging that the death was by suicide, then it really becomes challenging.
But that's why I'm saying do it like we had this many, like we are collecting serious suicide attempts and sentinel events. So we're going to put it in a way that just talks about that the organization is definitely got their eye on it, making it, like doing improvement, reviewing them in that context. That's the best way to do it. Even if a family says yes, it's going to be a problem. Which one?
All right, thank you. Another question. Are on-campus counselors considered health custodians?
It's depending on where they're working. If they work for the clinic,
the counseling services, or student health services.
Yeah. If they're working for and if they have their own, Inc., if they're an agent and just coming in and providing services, they're all HIPs. If they're providing mental health and addiction services, is considered healthcare. Like it's all under the same umbrella.
Okay, great, thank you. And another question is, if a student hands in a medical note as part of an academic appeal, does that fall under PHIPA?
Not if it didn't go to, it actually falls under his student record, only the part of the student record that is separated for healthcare. So like our employees here, they have an employee record, but part of that record is their health record, part of their employee, but these are like two separate things. But if it was given through, if that came through the clinic, the mental health clinic or the
student services or health services,
it's part of the record. It all depends on who's using it and for what purpose.
Great, thank you. And a follow-up to that question on campus counselors is, if I have counselors that are social workers, are they the custodian or is the college the custodian?
College.
Okay, all right.
Unless they're coming in on a contract and they're an agent. But if they're employed as staff by the college, that's who owns it. But really the client, but you know what I mean, who the custodian is, yes.
Okay, thank you. All right, lots of questions rolling in. Sorry, I'm just scrolling through some of them. And through all the people who are asking whether the presentation slides are going to be available, they will be made available. Okay, just looking to the next question. Uh, Sometimes the information about suicide gets leaked onto social media, and at that point, what should the university do? I think this is a follow-up to the suicide question.
I know, and this is where I felt a little bit out of my depth, but if it's there and it can be validated, we have people using Facebook when they're angry at us, and I've utilized that. Because risk trumps, I would take it seriously. Just think of it this way. You're sitting in a court of law, and they ask so you saw that and you did nothing.
I think they're talking about after a suicide has occurred, and then somebody posts. Is that correct?
Yes.
Yeah, so somebody has died by suicide, and now that's part of the social media narrative.
So again, I think it really looks at what the university or college's position is on those scenarios. Again, if the death happens in your residence and the family is putting it out there.
So I think the best standard on health information management, if that person was in the clinic, they would say that they would write a document saying that they saw something, if it was relevant to the death, because when they died, there's no more provision of health care, right? Mm-hmm. However, if there's something on it that speaks to the quality of care review, you know what I mean? Like if they're doing a review and it's relevant, you would document that this was seen. Otherwise, it's
really up to the university on how they want to tackle that problem.
But I think the university are asking.
Yes, and I think it really depends on the situation. I know we have found in working with our university partners, a lot of it comes down to what does the family want to share?
Yeah, but I wouldn't take something off of social. Like when we don't know how a person died and it's relevant to our quality of care review, we would say social media said they hung themselves, and that's it. But all of the other stuff, no, because you no longer have the authority to collect, use, and disclose PHI.
And I think this is a bigger question that we probably, that could be another webinar on its own.
Yeah, but you might go legal counsel, but if you, like, we're going back to information management. So what are the best practice standards that the college has around information management? Now, the ones that are HCCA, they have health information management standards. And they're under FIPPA, there's a whole bunch of standards around information management, and that's your guideline.
Okay, thank you guys. That's a kind of a tricky question.
Yeah.
Next is, when students disclose PHI to non-health information custodians, so such as faculty, etc., do they still have obligations under PHIPA?
Oh boy, that's a hard one. So that's like, yeah, no, the reason usually it's case by case. If it's risk information, it's not that the faculty they're not under PHIPA, but there is that permissive part of both those legislations to collect and do something with that information. But not generally. If they're just telling them all this other stuff, they have no obligation to collect. But risk, given those examples we have with Virginia Tech, those were the recommendations that came up that weren't shared. So if I was a faculty member and someone came in and said, look, I really have some great difficulty and I have thoughts of killing myself, I even under FIPPA, that would be collected and then shared appropriately. You err on life.
All right, thank you. Can one health information custodian on campus share psychological and psychiatric reports from an outside organization with another on-campus health information custodian?
Yeah, as long as they have in place that framework. So they either have implied consent with notice, or they have express verbal consent, or they explain it. That's the example of the interprofessional care component. But CMHA can talk to, which one do we talk to the most? The Guelph one? What's the one that?
University of Guelph?
Yeah, right. And what's the name of her program?
Would be their counseling services.
Their counseling services. They're two HCCs, and we're sharing for the purposes of one student. Yes. As long as that student is aware that we're working under that implied consent. So if he goes to my website, he sees that. If he goes to the university website around his rights, he sees the same policy. It's what has to be visible, because that is true circle of care, and that is the way it should work for client safety.
Great, thank you. Last question, because we are running up to 1 o'clock now. So apologies to anyone that we did not get to answer. If we have received PHI from another health information custodian in our clinic, can we send this information on a referral form for the purposes of helping the student if it was obtained with the student's express consent?
Okay, so you're hitting on one of the biggest issues on what is the health record. So this went to the Supreme Court of Canada, but anything you collect and put onto your record, even if it's not authored by yourself, in all intents and purposes, it now belongs to the custodian that collected it. So if for the purposes of healthcare, you're attaching it to a referral to go to another healthcare provider, not third party, you of course can do that. And you've added the extra part that says with consent. But you can do that because the Supreme, I can send that. I didn't put it in this slide, but this is the biggest misunderstanding. That student record is everything that's collected, which could be several other organizations, belongs on their record where they are receiving services. And they should have the ability to have it streamlined for them to go. So yes, definitely.
Wonderful. Thank you so much for those really comprehensive answers and a great presentation. So now I'm just going to roll up. Thank you. And thank you everyone for joining us. Now I'm just going to spend like 1 minute. I know you all need to go. 1 minute to talk about our community of practice. We've partnered with EENet at CAMH to host an online space where our webinar participants can continue to ask questions, post discussions, and network with other people in the sector. So I'm just going to send a link in the chat box to everyone. And I'm going to pull it up on my screen right now so you can see what that looks like. Give me 2 seconds. Okay, and there we go. All right, so this is the CICMH Community of Practice. As you can see, we have, well, only one forum right now, which is the Health Privacy Issues on Campus. And the webinar presentation and recording is going to be made available here. Okay, so if you have any questions, you want to sign up for the community of practice, all you need to do is just follow that link that I've sent, and I'm also going to send it out in the follow-up email after the webinar is done sometime tomorrow. So do sign up to the forum. You can post questions, continue the discussion that we've been having here today. Okay, and hold on. Okay. And the other thing I just want to mention really quickly is we do have another webinar tomorrow, which is Evaluation 101, Learning How to Conduct Evaluations of Programs and Services, which is also the launch of our online evaluation toolkit. So do tune into that, and don't forget the survey that's going to pop up at the end of the webinar. So thank you everyone for attending, and thank you so much to our CMHA Waterloo Wellington folk for joining us.
Thank you.
Thank you.
Thank you.